data sovereignty is the area of the law that relates to legal rights in data, who can access it, who can protect it, what you can do if it's yours, what you can do to stop other people getting their hands on it. It's a pretty new area of the law, and it's a collection of other areas. But I just thought I'd rip through some of the areas tonight and tell a few stories, just so the people who are actually in charge of this stuff, which is you, have a good sense of what the law is around keeping control of the data that you're responsible for. So I'm just going to talk about these 6 areas. Please jump in at any time if you've got any questions. So the first 2 are probably pretty straightforward and everyone knows about them. And this has to do with access under regulation to data. So there's right to information. And that means there's a general right to access government documents. So if you work in the public sector, you probably know all about right to information. There's a process you go through, there may be a cost, and there are some exceptions where, for example, confidential documents are concerned. So I won't spend any time at all on right to information, other than to know that if the government has some data, it's potentially exposed to other people accessing it, and if you work in the public sector, it means that people outside can potentially access your data. Lots of people write lots of books on right to information, but that's the general shape of it. The next one is privacy law, information privacy law, and that's the general right for individuals to access and correct information about themselves. That's not just with government, that's with anyone. So if you hold a database of people, customers, if you run a website that has members that post to it, if you have any of those kinds of collections of data that relate to specific individuals, then the individuals have a right to access the information about themselves and to correct errors in that information. You're allowed to charge for the access. So if somebody applies to, for example, applies to you and you run a website, which is say a bulletin board type site with members, and somebody writes to you and says, I want to know what information you have about me, you can say, well sure, I'll tell you, and the charge is this much. The only limit on that, it can't be an excessive charge. So that's anyone, pretty much anyone who collects personal information about identified individuals. And there's some exceptions to that. You mustn't disclose information about other people, it's only the individual themselves. And there's exceptions, for example, if someone's in negotiations with you about a commercial contract, for example, they can't then turn around and say to you, oh, can you please tell me everything you know about me, because that would wreck the negotiations. So there's a couple of exceptions, but generally speaking, people are entitled to get the information about themselves. The next one is litigation disclosure. That's a little bit more esoteric, and probably not as many people will have come across this, but if you've ever been involved in any sort of litigation, you'll know about disclosure. And what that is there's a general duty to disclose relevant documents in litigation. And it can be a significant exercise. Typically when in large litigation, after the parties have decided between themselves what they're actually in dispute about, so when the lawyers say when the pleadings are closed, which is the parties have actually concluded between themselves what they're fighting around, disclosure is the next huge exercise, and there's companies that are in an advisory role that do just disclosure and nothing else. And what they do is things like make tools to trawl through email databases and to go through document repositories looking for relevant documents that need to be produced in litigation. And here's the bit that relates to sort of digital materials. is in the relevant rules, document, in the sense of you've got a duty to disclose documents, includes any disc, tape, that's the law illustrating how up to date we are in talking about digital media, any disc, tape or other article or any material from which sounds, images, writings, messages are capable of being reproduced. So there's a few bad examples and then there's a catch-all. So it means basically anything from which information can be reproduced. So I think the takeaway about litigation disclosure is if you're ever in a dispute or even if you're ever thinking about dispute, suing a customer, having a dispute about copyright with someone who's pinched your designs, be aware that any material you have could potentially be the subject of disclosure and sent over to the other side. And that includes all sorts of internal emails discussing the dispute. The only thing that's excluded from those rules are privileged documents. Essentially, that is your exchanges with your lawyers. Everything else that you hold could potentially be given to the other side. So it's a good one to sort of put in the back of your mind as a knowledge of what could potentially be exposed if you get into a fight. Sorry, there's a question at the back.
How does that work with email and staff and personal email?
Right, so the question was how does that work with emails and particularly personal emails? And the answer is certainly emails can be subject to disclosure because they're documents, right? And in relation to personal emails, it doesn't matter that they're personal. The disclosure rules say if a document is relevant to the dispute and it's within your control, which it would be because it's on the organisation's system, then it's subject to disclosure. It wouldn't be a defence to disclosure to say, oh, this is a personal email, maybe talking about the dispute so it's relevant, therefore I don't need to disclose it. So, right, so that...
So your staff name's got a personal email account and they're talking to your clients.
Right.
And that's the dispute.
Right. Okay. So the question was if the staff member has a personal email account, and the answer to that is if the information, if the communication isn't in control of the organisation, it's not disclosable because it's not within their control. But I'm going to get onto this a little bit later. It is possible to get disclosure orders against third parties. For example, whoever's running the email system. So you could get an order that Google Docs, for example, disclose emails or documents on its systems that relate to your dispute, and Google would have to comply with that. And I'm going to talk about those issues a little bit later. This question over here.
What about in the margins? What if you're an owner of a company and you've got your own private email address with Google or whatever, and you've got a company email with your company? Would your private email be subject to that considered third party?
Yeah, it goes to whether the material is within the control of the organisation, and probably if it's within the control of the organisation's chief executive or owner or manager, I think it probably would be. So yes, you probably do have to disclose what's relevant in your personal email that is within the reach of the company. If the company is basically you, that essentially means everything that you control. So that's litigation disclosure, just one to keep in the back of your mind. Next I'm going to talk about subpoenas. Now subpoenas, it's Latin jargon, it means under penalty. And a subpoena is a court order issued at the request of a party directed to a third party, someone not associated with the dispute. So what happens in a subpoena is if you've got a dispute already on foot, you can go to the court. This is the Gmail example for the Gmail question that relates to how you access material on other people's servers. So if you're in a dispute, you go along to the court and say, I think this particular other person, be it Google or be it Telstra or whoever it is, has material that is relevant to this dispute, and I would like you to order them to deliver it up. And the court will make those orders in certain circumstances. And they usually make them as a matter of course. Like, it's usually something you can get effectively over the counter at a court rather than going before a judge and arguing for one. There are some exceptions. The request has to be narrow enough the party can respond to it. You can't just say to Google, give me all the documents that you own, or that might have been sent at a particular time. You have to be quite specific about it, and you have to pay the costs. And there's that privilege exception again. You can't get hold of communications between a party and their lawyers, even going through that third-party route. I might just go to this slide and come back. This is an example of a subpoena for production, honestly. And so what we did was we went to court and said, can you give us a subpoena addressed to Telstra and Vodafone, who we determined were the people who managed the IP ranges that the emails appeared to come from. And we said to the court, can you give us an order that Telstra and Vodafone tell us who your customer is that was using that IP address at that particular time. Pretty straightforward, and you will see there's a little table at the bottom of the first page there that contained the date and time of the email and the IP address, which I've blurred out. And that was issued fairly simply as a matter of course. Telstra's costs to respond to this sort of subpoena, I think it was $50 from memory. And it was a way of tracking down someone through a third party. So in this example, it was using a subpoena for what's known as identity discovery. And identity discovery kind of sits on its own as a legal area. So identity discovery is the exercise if someone has information to identify someone in order to commence proceedings against them, for example. So if you know somebody's registration number of their car, you can get a subpoena addressed to the Department of Transport to find out who the registered owner is, and therefore find out who the driver is if they hit your car and drove off. Probably more relevant for this audience is the kind of subpoena I just talked about, where you can go from an IP address, for example, of someone who made a post anonymously on your site or sent you an email anonymously, and you'd like to track down who that was. Potentially you can, by way of a subpoena addressed to the ISP, Telstra or Vodafone or whoever. There's some rules about identity discovery. You must potentially have a civil legal claim against the individual. You can't just go around subpoenaing people's registration numbers because you either like or didn't like the look of them on the street. You must show that the recipient, as the Telstra or the ISP or whoever, has relevant information. It's pretty easy with an ISP because everyone knows they maintain customer records and then they associate them with particular IP addresses at particular times. But sometimes you need to convince a court of that. Judges they're very good, but they aren't necessarily 100% up to speed with how the internet works, so sometimes you have to prove that. You need to be highly specific in subpoena. So, for example, when I showed this one, you'll see that the table had sort of times down to the second, and that just obviously comes from the email header that we received. So we know the email was sent at a particular time, from a particular IP address. With that sort of specificity, you get the subpoena issued fairly easily. If we didn't know dates and times, it might be a bit more difficult, and the recipient of the subpoena might have a bit of a problem with it as well, because they look at it and say, well, we can't do that because we don't keep that detail of information, or it'll be too much of an exercise for us to us to dig it out, or it'll cost too much. So there's a question at the back.
Is this just for Australia only?
No, but it is a lot more difficult to get a subpoena against a company internationally or an organisation internationally. It's possible to do, but you effectively need to go to have the document issued in Australia and then go to a US court and have an equivalent document issued there. So it can be done, but it takes significantly more time and significantly more cost. Yeah. Sorry, I say that because I've done it recently. The same would apply in any other jurisdiction. But because so many of the sort of big holders of information, all the cloud computing people are in US jurisdiction, it's almost always the states that people want to go to if they're not in Australia. But yeah, the same applies in elsewhere. Sorry, there's a question over here.
So what about third-party sites? Say people are reviewing third-party sites and they're like an anonymous user, they don't put their name to it.
Yep.
And you can see the system that happens.
Yep. So the question is, what about third-party sites that you don't like the content of? With that, it's a two-stage process, right? So you need a subpoena against the operator of the site who you know, and you say to them, we would like the IP address of user whatever random name who posted these posts at whatever time. And they respond to you with an IP address, hopefully, and then you take that IP address and you say to the ISP who's responsible for that range, we want your customer information for the person who had control of that IP address at that time. So it's a little bit more long-winded because you have to go through twice, but ultimately it's possible to get the customer. Now all this presumes that the individual who's doing it is sitting at home using their own internet access account to do whatever they're doing. If it's someone going out to an internet cafe and posting from there, it's impossible to discover who that person is. Unless you're the police and you have the power to, and I'll talk about search warrants in a minute, you have the power to find out the time that the posting occurred and seize the video surveillance tapes of the internet cafe. But that's probably too much of an exercise. So you might be able to get a subpoena for that information, but it would be an incredibly long way around. And even then, you've just got a picture of a person. So I don't know if that helps you. Sorry, so that was a long way around to answering your question, which is posting on third-party sites. Yes, you can get there, but it's a couple of steps away. Sorry, there's a question over here.
Yeah, so what if third-party website doesn't have any information identifying the person? Let's say they know the store IP address of the post.
Yep, there's no obligation. Subpoenas only oblige you to disclose, to provide information that you have. So if you hit a site that says, oh, we delete all our records on a daily basis, or we never keep the records in the first place, they don't have to. You might be aware there is a proposal for a law that sites like that and ISPs be obliged to keep information for 2 years. Now there's lots of policy and freedom of information and personal liberties arguments on both sides of that equation, but from the point of view of tracking people down who have done wrong, or you say have done wrong, it's a good idea because you can then go through these processes and find them. From the perspective of civil liberties, maybe not. I can just speak from the perspective of needing relatively often to track down people, and it's of a great help that companies do keep records. Sorry?
Do you have to prove at how many levels that the post is slander providers first, like adding what the reason for tracking down?
You don't have to prove the case completely. Sorry, I should repeat the question. The question was, do you have to prove there's a reason? Do you have to prove your case? And the answer is, you have to have a claim. You don't have to prove that your claim will succeed, But you can't just get a subpoena on no basis whatsoever. So when you go and ask for a subpoena, you will need to say, oh, and the reason I need this information is because I say it's a defamation, or because I say it's someone who hit me in a car and drove off. You can't just do it on a whim. But you don't have to prove it.
Do you have to provide any, I mean, not the legal definition of proving it, do you have to provide any evidence of that, or is it up to the...
Well, here's the funny thing. Subpoenas are effectively issued over the counter. So nobody really looks at it when you get them. But what happens is the person who receives the subpoena might then say, oh, hang on a minute, this looks a bit dodgy. Or you might end up in having been reviewed subsequently, having sought a subpoena on no basis. And then, because it's all in the hands of the court and you've kind of convinced the court to issue an order, which they probably shouldn't have done, you're potentially exposed to contempt proceedings. So it's not a good idea, and there is a penalty, but you might not get found out for a little till after the fact, put it that way.
I'm sorry, I'm breaking a little bit off topic.
No, that's right.
Couldn't you then, if the example you proposed, couldn't you then, if they had kept records, couldn't there's some kind of order to get them to take it off if it's found to be violating? You don't necessarily find the person who posted it.
Right. So the question is, can you do something about a posting even if you can't track down the person who did it? And the answer is yes, you certainly can. That's not really subpoena law, that's an injunction. And yes, you can get those relatively easily. And the magic of not having been able to track down the person who did it is you're effectively then unopposed in your injunction application. So you say to the court, I've tried to track down this person, they've deliberately tried to maintain an anonymity, this posting's defamatory or whatever you say it is, I would like an injunction against the publishing site that it be taken down. And the publishing site usually shrugs its shoulders and says, that's fine, you know, you go to court and come back with an injunction and we'll comply with it. So yeah, there's a few steps, but it's a lot easier than having a contested application. So that's identity discovery. Talked about that. This is just the response of the ISP, who are quite friendly about it. And in fact, they have the big ones have a special group that deal just with both civil law subpoenas and also police warrants. And when they have a properly served and issued subpoena or a police search warrant or request for information, they just write to you and say, yeah, the person who's using this IP address at this time was this person, full name, full address. So it's very, if you follow the process, eventually you get the magic letter and you're home and hosed, because it's very difficult then for this person to deny that they have sent these anonymous emails, because how would you otherwise come up with their details? Hopefully I've blanked out the person's name in this one. Some tips about what if you're responsible for a collection of data, like membership data or any collection of personal information, and you receive a subpoena. And anyone can be served with one. So just some very, very simple rules. Just check if it's actually been stamped by a court, and it's got to have to send them out without actually having a court issued them. They're just sort of amateur subpoenas. So I've seen that before. It's like the people who send debt collection notices in the form of a court order, which aren't really a court order. That's just words somebody's written on a piece of paper. So check that. If you like, you can ring the court. So if you get a subpoena and it looks a bit dodgy, or you're not sure if it's correct, just look at the name of the court at the top. So the magistrates, district, supreme, federal. That's an increasing order of how much trouble you're in. And ring the registry and say, I've received this subpoena, it's got this filing number, and they'll say, yes, that's a file we have and we issued the subpoena. Is it addressed to a particular individual? Because they must be addressed to a particular individual. In an organisation, it's often the proper officer, which is fine. That just means whichever officer in the organisation is responsible for complying, but it can't just be addressed to the directors or to the organisation itself, so check that. Is it specific? Have they sent with the subpoena enough money for your costs? So if you think it'll take you 10 hours to trawl through your database and find out the information that's been requested and photocopy it and send it to the court, you can check whether you've got a cheque attached to the subpoena for a reasonable fee for doing that. Has a reasonable time been allowed? It's usually 2 or 3 weeks to respond to a subpoena. And the last one is manage them. If you do get a subpoena, make sure you comply with it, because if you miss the date, you're potentially liable for contempt yourself for failing to comply with a court order. And big organisations like ISPs have, as I mentioned, groups of people who manage the diaries very carefully to make absolutely sure they comply, because Telstra or IINet don't want to be hauled up for contempt for missing a date. Yep.
What do we do if the reasonable costs covered within that's
the first thing you would do is negotiate. Sorry, I should repeat the question. The question is, what do you do if you don't think the reasonable costs have been covered? And the answer is, the first thing you do is ring the person who sent you the subpoena and say, you've asked me to spend 10 hours work and you've sent $10, and that's not enough, obviously. And you would have in mind when you make that call how much you would like, and usually they will just send it to you, because frankly, in the process, the conduct money, as it's called, is fairly small in the lists of costs that you're incurring in pursuing this stuff. So usually they will just send it to you. If you don't get any joy there, if they say, we think you've sent enough, strictly speaking, you don't have to comply with a subpoena if your costs haven't been covered. So you would write to them. Don't do this bit on the phone. Make sure you write to them, because there needs to be an evidence trail, saying, we received your subpoena, we received this much in conduct money, we don't think it's enough, therefore we're not going to comply. And that will eventually go before the court, and the court will say, we'll make a decision on that. But you should probably get some advice at the same time, just to make sure you're not being crazy about it, because there's still a risk of contempt there.
So
yep.
I'm assuming you're dealing with Telstra and they've got procedures. If you're
Yep.
dealing with someone who's small, do you bring them beforehand and go, come after this, or are you cost likely to do so?
Yep. Yeah, that's exactly right. Sorry, the comment was, would you negotiate before the subpoena was issued? And the answer is yes, absolutely you would. You'd ring them and say, you've got the subpoena, or you're about to issue one, what will the cost be? How long will you take to comply? You can even ask them, have you got the information? The only reason you wouldn't do that before you actually served it is if you thought they might delete the information. Because if they delete it before the subpoena arrives, it's gone. If they delete it after the subpoena arrives, it's still gone, but you've got potentially proceedings against them for deleting information in the face of a subpoena, which is pretty bad. Yeah, that's a good point. Talking about orders which may arrive at your door, the next one in the sort of escalating scale of severity is what are now called civil search orders, and used to be called Anton Pillar orders. Anton Pillar is just the name of the first case in which this kind of order was issued. And what Anton Pillar orders are, civil search orders, because I studied law a while ago, I always call them Anton Pillars. But what civil search orders are orders just saying, well, entitling someone to search premises. And they're issued ex parte, which means they're issued without informing the subject of the search order first. And they're usually issued in intellectual property matters where there's some sort of risk of destruction of evidence. Wouldn't usually be issued in the same area as the subpoenas we're talking about. It's usually when you're going in looking for crates of CDs or crates of same but different handbags, that sort of stuff. And there are a whole bunch of rules that the courts have developed about how you issue and serve Anton Pillar or civil search orders. So daytime only, business days only. There's also a rule that if it's expected that there only be women or children at the premises, then they ought to be served by a woman, etc., etc. So if it's for the protection of the person who the order's being served on the basis that it's going to be a crowd of people turning up at their door, banging on it and demanding to get in. The digital information aspect of this is, and this law has only sort of come in the last 4 or 5 years as all business records and potentially lots of IP information is migrating to digital-only copies. What they usually permit, these orders, is taking of forensic copies of data and systems. So some, forensics expert will show up with a great big bag, and in it will be a computer with a lot of disk drives, and they will come in, plug it into your computer, and copy the entire disk drive from it. And then they'll go away and analyse that copy to see if there's any relevant data on it. And the orders usually allow, sorry, there's a question here.
What happens if you put encrypted data on the drive?
That is a very good question. The question was what happens if there's encrypted data, and the next point covers that, which is the order also usually requires a subject to provide assistance. And assistance might include providing passwords to access and probably also passwords to decrypt an encrypted drive. I expect that there will be a rash of my memory's suddenly gone, suddenly that you guys are here with your forensic kit. I can't quite remember what the password is to unencrypt my volume. Because if you do it knowingly, you're in contempt of the order because you haven't provided assistance. And I'm not encouraging anyone to be in contempt of an order, but I'm saying it would be quite difficult for a court to tell the difference between someone who's genuinely forgotten and someone who hasn't genuinely forgotten.
Can you argue any sort of relevance to the encrypted data, or are they just assuming that you're going to be hiding the encrypted data, you can't see it?
They just, the question was, what, can you say it's relevant or irrelevant? And the answer is, there's just not enough case law in this area to know what view the courts will take. The courts are very sensible and practical in these areas. They usually think if what's worth hiding is usually probably something that's incriminating you. So if you are subject to this kind of order and you do take steps to hide or not cooperate or not comply with the order, usually a court will just assume that you're potentially liable. And the consequence of that might be worse than having provided the information in the first place. So what happens is, so the question was what happens to the material that's taken? And the answer is, one of the conditions of these orders being granted is that an independent lawyer goes along with the crowd of people who are serving the order, and typically the independent lawyer will hold the material, and ultimately the material can be delivered back to the court, so that it's not basically in the hands of the opponent in litigation. It's just, the point of the exercise is to stop evidence from being destroyed. So the point is to take it away from the person who's potentially holding it, not to give it to the other party. So we usually end up with the court registry.
So if it is actually relevant data that you've got encrypted, that won't actually end up in sort of being replicated and copied all over the place?
Well, it still might, because it's still effectively sort of being discovered in these proceedings and will still need to be analysed. Pretty much as soon as it's been discovered that it's not relevant, people will just ignore it and hopefully return it to you. Sorry, question at the back.
Do you have the right to allow them to sample data
The question is, what rights do you have to point out relevant and irrelevant material? And I'll come to that on the next slide. Oh, sorry. Here's an example of a civil search order notice. So this is the document that will be handed to you if someone pounds on your door and wants to serve one of these. I couldn't actually find one that I'd done, so this is a mock one, but they contain lots of scary black letter capitals about how you must comply with the order. And the idea is it's very confronting when these things are served on people, and so it's the point of the standard form of this is to make very clear to someone that this is the court that's doing this, and these are the requirements. You need to comply with the order. If you don't comply with it, you'll be in contempt of court, etc.